Good afternoon, and thank you for joining us today. I would like to welcome you to Fortney Scott's 2022 Workplace Agenda webinar series. I would like to address some preliminary items before we start today's briefing. Currently, all listeners' phones are muted. At any point in time during the presentation, please feel free to submit a question in the GoToWebinar question box. We will try to answer all questions. Today's topic is the NLRB moves aggressively. Our presenters are Fortney Scott attorneys David Fortney, Bert Fishman, and Nita Beecher. I will now turn the program over to today's moderator, Nita Beecher.
Thank you, Valerie. We're really happy to have you guys back with us again. Hi, David Fortney and Bert. How are you guys doing today?
Hey, Nita. Great. Really looking forward to talking about one of the most activist agencies we've got going here in Washington. It's going to be fun. Hi, Bert.
Yes.
Yeah.
Hi. As an old labor lawyer, you don't get a chance to talk about the NLRB much in the last 20 years, so it's kind of exciting.
It is exciting. So before we get Bert and David started, let's go to the next slide. And we just want to remind you all, of course, that we're Fortney Scott. And we'd like to remind you that we're a woman-owned Washington, D.C. law firm, that we specialize in workplace matters of all kinds, including National Labor Relations Board. And we'd like to also mention that we are doing a biweekly podcast, often featuring Mr. Fishman, Mr. Fortney, and myself, and we'd love to have you join us to hear those there. And we will be doing a podcast in the next week or so on this very subject. Going to the next slide before we kick it off, this is kind of what our agenda for this presentation is. We're going to talk about the current status of the Biden board, of the NLRB, and then we're going to talk about the Biden board. One of the hottest things right now is the General Counsel's memos, and it gives us an idea of what to expect from the General Counsel, who is very aggressive compared to a number of the other agencies. Then we're going to talk about the fact that the board is about to switch back to the Obama standards on a number of topics, and we'll talk about that. And finally, something, David and Bert, that's been a theme throughout the Biden administration, which is the coordination among and between various agencies. You all in particular are going to talk about the board and DOL, and we'll also mention the fact that there's the retaliation among and between the NLRB, EEOC, and the Labor Department. And with that, David, let's kick it off with you to talk about the Biden agenda and the board.
Hey, thanks, Nita. Gosh, there's a lot. As Anita's indicated, the NLRB has really proven to be one of the most active and I would say well-organized agencies within the Biden administration. The concept is, at least from this administration, that the labor board's primary role, it appears, is to really promote unionization and pro-union efforts. And there's not much subtlety about what that objective is. Initially, there was a great flurry, of course, with the PRO Act, the Protect the Right to Organize Act, that was subsequently actually renamed slightly to recognize Richard Trumka after his passing, former head of the AFL-CIO. But I think at this point we can safely say that the PRO Act is dead in Congress. The current cards, it has been passed by the House. It will die and has died in the Senate, and that's where it will remain, I think. Which, interestingly, although that's a defeat for organized labor, it actually puts more of a premium on the labor board and what's going on there. And I think that that's one of the things, Bert, with the new majorities that the president's appointed, and we'll unpack that in a moment, but I think that's one of the things that really amplifies why the board for this administration is more important than ever.
Yeah, I couldn't agree more. And that has to do somewhat with the nature of the board. And if we can go to the next slide, you'll see what I'm getting at. The NLRB is, probably the oldest super agency, founded in 1935 with the National Labor Relations Act. And its intent was really to enable unions, to create rules of the road. But since especially 1947, the Taft-Hartley Act, it's been one of the most highly politicized bodies in all of government. Every time a president of a different party changes, the board members change, and as a result, the decisions of the board change, and that creates a kind of seesaw, as you can see on this wonderful graphic that we have here on this slide. It creates this kind of seesaw movement between pro-worker, pro-union versus pro-management, and it has the ultimate effect, I think, of diminishing and undermining the respect for the board. There is no such thing as what judges called stare decisis. There's no reliance on precedent. And as a result, there are no reliable precedents. And almost certainly what we're going to see here is, because of the highly politicized nature of the board, the announcement by the General Counsel, whom David just talked about, to kind of re-examine and frankly overturn many of the decisions reached in the previous 4 years, creates this kind of instability in the workforce, which we really don't need right now with the impact of COVID and all of that. But that's what I think we're going to be seeing.
Yeah, I think that one of the things that we always talk about personnel as policy, and I know we're going to unpack who the board members are, but this overt willingness to simply say, look, we're in charge now, so we're going to revisit these precedents and summarily reverse them without any real apology. And what this does, I think, for employers, it does start to set a horizon concept, meaning the next 2.5 to 3 years, honestly, it's going to be tough sledding for employers. Where there's any doubt in how the employer's interests versus the union interests align, to the extent the most aggressive reading of the law permits the board to go pro-union, candidly, that's what we expect.
Well, one of the things that we have to recognize is that the board makes its rules through decisions on cases. And one of the criticisms of the board, and it's fully justified, is that the process is amazingly slow. And then all of those board decisions are subject to judicial oversight and appeal. So 2.5 years is probably what a case takes to get through the appellate court. So all of these endeavors, all of these hopes, all of these goals, all of this aggressive moving forward may not come to fruition. Nita?
One important thing I think we need to remind everybody is that we're talking about the National Labor Relations Board. People usually think that's union versus employers, but it applies to all private sector employees, and it protects their right to concerted protected activity. And I know we're going to talk about that a little bit more, but since so many people are actually not in unions, I think that's a focus we're going to see here with this board.
That's correct. And this is why, particularly because let's face it, roughly 95% of the private sector are non-union today, yet that 95% still has a direct interest in what this
I think we can see that on the next slide. I'm sorry, I didn't mean to. I think we can see that on there. It is.
Yeah. So, and that really, this slide demonstrates, that the labor movement is at, relatively speaking, historical low tide. And this goes back for years. This trend has been occurring. But it's interesting, a question that's being asked now is, has the pandemic resulted in a willingness by workers to revisit reimagine whether unions can have a useful role? In my opinion, we don't have an answer to that question. The question's being called. Many in this administration do believe that unions, starting with the president himself, who unabashedly is a pro-union person, starting with the Secretary of Labor, who is a member of the building trade union, card-carrying union member. But does that mean, are they really aligned with the majority of the workforce, including what about those gig workers? We'll talk a little bit about how they fit into this, but the workforce itself has changed too.
One thing we're seeing too is coming out of the pandemic, just to reinforce what you're saying, David, is there are a bunch of Starbucks stores across the country that are moving to organize. And I know we'll talk a little bit about some of the unusual shapes some of these pseudo-unions are taking, like with Google and the tech companies. So I think what you're saying is true, that there is a movement for employees to have more power.
Certainly, organized labor views it as the Great Awakening, and you have the traditional organizing, Amazon's warehouse workers, Starbucks baristas, a growing trend. Notice that you have to organize by a community of interest, and so it's at those particular establishments. So Starbucks has the tactical benefit of requiring location by location to be organized. But then there are these other alignments that look more like the European Workers' Council, and that's really more where the gig workers, and we'll unpack that a little bit, kind of fit in. All of which suggests many in the administration view that their goal is to make that chart that we're looking at right now, that line needs to change direction and start moving up. We'll see.
Yeah. Well, if we can go to the next slide, we'll try to get a sense of who's going to do what is supposed to be happening. You know, as David mentioned, personnel is policy, and these are the new persons, and it is a new board with the Democratic majority, first time in 4 years. Lauren McFerrin came out of one of the leading labor pro-union law firms in Washington, Bredhoff Kaiser. She's now in her second term on the board, and they have staggered terms, but she's just been appointed chairman, and she will be in that role till 2024. John Ring is a former chair. He's a Republican. He's just the opposite of Ms. McFerrin. He's a well-known management lawyer from Morgan, Lewin, Bockius, and he will be there till the end of this year, till December 2022. Marvin Kaplan is another carryover. He came out of government. He worked on the Hill. He worked in OSHA, in OSHRIC, which is the kind of NLRB for OSHA concerns. And he's going to be there till 2025. And here are the two new members. Gwen Wilcox, who will be there till, I think, 2023. She was the chief lawyer for 1199 of the Service Employees Union Workers in New York, and we'll talk about this later, was involved in some of the cases that came before the board. And David Prudy was the general counsel of the SEIU, the Service Employment Union. And it clearly, new members means new outcomes. The panels are random, but with a 3-2 majority, you will almost always get a Democratic majority on the panels. And we expect, as I say, the board rules on cases, and their new rules will come from those panels, and there will be a Democratic domination. Nita?
Isn't Ms. Wilcox the first African-American woman to serve on the labor board?
In my understanding, yes. There have been many black men on the board, but she is the first black woman to be on the board.
So that's a milestone. But the three Democrats really have very deep, profound union pedigree, unabashedly so. We have two SEIU former representatives, very senior representatives, and Chair McFerrin, in addition to her private practice, also was on the Hill with Senators Kennedy and Harkin. She was counsel for the Labor Committee and the Senate side. So, and interestingly, she was initially appointed by President Obama and then reappointed by President Trump. So for those that are sort of keeping score, you know, that she's there, but and the change, Bert, you mentioned the change that John Ring formerly was chair, and that, of course, President Biden gets to pick from an existing board member who's his chair. And so that's not unusual. That's not, chairs serve at the pleasure, not, they continue as a board member, but their role as chair is determined by the administration. So the fact that President Biden said to Mr. Ring, thank you for your service as chair, and Ms. McFerrin, you may now become the chair, is pretty much standard operating procedure. That is how the board that operates.
As you'll see on the next slide, David, maybe you can help us. There are new conflicts because there are new members.
Right. So this is interesting. During the, it used to be, you know, in the day, as they say, that is someone who came out of either, you know, deep experience in representing employers or deep experience in representing unions were viewed as offering just that, great expertise and experience, and of course, put them on the labor board because they understand the law, they're steeped in it, they've practiced in it. Well, what happened during the Trump administration term was that the question of whether there should be recusals began to surface. Now, again, a recusal isn't necessarily new. That's a standard concept. And the rules are pretty much self-evident. You shouldn't be working on a case that you were directly involved in when you were in private practice. So, and board members, when they assume those roles, fill out a background information so they can make sure there are no conflicts. What happened in the prior administration was that some of the Democratic members teed off and said, well, it isn't just whether the individual board member worked on a case. What if their former law firm was involved in a case? Now, this was a rather new, stunningly expansive view of whether a board member should or shouldn't be recused. And this was pursued zealously. It was pursued by the Hill through oversight hearings. It was pursued by the National Labor Relations Board Inspector General. And I know one of the board members who faced these claims, from conversations I had with him, ended up expending over $100,000 in his personal funds for counsel to represent him in all of these oversight proceedings. So what is the message of that? It does, obviously, it potentially has a chilling effect on which cases you can become involved in. It has a chilling effect on whether those that are deeply experienced can serve on the board. And as a practical matter, you can certainly expect that the business community is going to return the favor of aggressively deploying the conflict issue, particularly for the two members that Bert, you've identified, that are former SEIU. Most of the board's docket has SEIU as a party. Well, does that mean two of the three Democratic members are recused because whether they were directly involved in those claims, their former organization, the union, or their former law firm certainly was? Under the prior rules that have been established over the last 4 years, the answer would appear to be yes. And how does the newly constituted Biden board work in that environment?
Well, I can also add, from what I've heard, the events of the last 4 years have really poisoned relationships on the board. And it used to be fairly, amiable and
collegial.
Everybody knew who they were and what their positions were. And now it's, the knives are out. It's going to be no fun at all. So if we can go to the next slide, let's talk about...
I'm looking forward. Next week, I'm going to spend a little bit of time with some of the board members at an American Bar Association meeting, and we'll see how the collegiality is. We'll see. They'll, I'm sure, put on their best face of things. But let's talk about, Bert, the General Counsel, because honestly, this is really the key appointed member, isn't it, of the NLRB apparatus?
The NLRB General Counsel, again, largely from its historic being the first super agency, the General Counsel got to define her role, and she is the person that makes the wheels turn. She is the one that brings cases before the board. She is the one that writes legal memoranda outlining the board's positions. And Jennifer Abruzzo here, who is a long-served board member, has served on the board for 20 years in a variety of positions, including Deputy General Counsel, became the General Counsel. She was appointed by President Biden virtually, the General Counselship became open virtually on the first day of the Biden administration when the president, in an unprecedented move, fired the sitting Peter Robb, the sitting General Counsel. It was unprecedented. It is still being litigated. I purposely put the description of the General Counsel that's on the NLRB website, appointed to a 4-year term and is independent. Well, the fact that the president fired the previous General Counsel summarily may question both the nature of a 4-year term and the independence of the board. That doesn't appear to have stopped Ms. Abruzzo. She is a staunch, outspoken advocate for unions and workers, and she has set forth an agenda of, David started by telling you that the PRO Act is dead. Ms. Abruzzo has taken the reins and is trying to effectuate through the NLRB, through decided cases, through GC memoranda, to try to animate all of the elements of the PRO Act that she can without legislation. It may not succeed because there will be court intervention, but that is her agenda. Nita?
So, Bert, can you talk a little bit about what the firing of Rob means for her, for Jennifer, and what has the board done to try to paper over the issues?
Believe it or not, it's not the first time we've had an unusual situation like this. Leif Solomon was appointed in a similar role, and they decided that because of there's a strange act about filling positions, that he was improperly appointed. Well, the succeeding board ratified all of Leif's conduct and said it was okay with them. Ms. Abruzzo was very careful about not doing anything that was reversible, but her predecessor, acting General Counsel Orr, did take a number of actions, and those have been challenged in the courts and are still being challenged, so that there may be some reversals of some early board actions in the early part of the Biden administration. For Ms. Abruzzo, of course, she lives under the threat of being fired if the president doesn't like what she's doing, although it's hard to imagine because she is his most effective agency head, but it does undermine the independence of the NLRB General Counsel.
Well, the other thing is, Bert, under the litigation challenging Peter Robb, part of the remedial relief is that Robb is reinstated and Abruzzo, her term is then terminated. In other words, her whole of the legitimacy of her appointment also is being questioned by those challenging the termination of Mr. Robb. So yeah. I would have to say, just going to say prediction.
Say as a remedy, I think that's beyond the power of the court. But
right,
who am I to say?
I was going to say, I think that ultimately most of the litigation involving the unprecedented and abrupt change in general counsel will probably come to naught, but time will tell. All right, well, let's talk a little bit. You mentioned about Abruzzo. Let's talk a little bit about what her agenda is, and I want those that aren't steeped in the labor board to understand. We refer to her title as general counsel, and most of us think, well, the general counsel is an advisor, a legal advisor, this type of thing. The general counsel at the labor board also is the one that, think of them more as a district attorney that sets the prosecutor's agenda. So the board members get to rule on cases, but which cases they're going to be ruling on, which cases are going to be presented, that determination is made by the general counsel. And now there's normally a consultative component, but ultimately the decider is the general counsel. So the position is one that has great autonomy and great discretion in driving what the new cases are that the board's going to determine. Bert's explained how the board members can often reverse decisions. Well, they first have to have a case to decide. How do they get those cases? The general counsel decides which charges will be pursued and litigated. And of course, recall that the labor board starts, they don't have independent, free-ranging authority. They respond to unfair labor practice charges, and then the general counsel and her team decide how those will be resolved. So, to make crystal clear what her agenda is, General Counsel Abruzzo has developed a well-publicized agenda. She started by issuing 21 memoranda, spelling out in great detail which rulings are on the chopping block, which ones she wants to reverse, and why. And what we'd like to do is really just kind of unpack some of those, because this really goes to some degree, even though they don't have the PRO Act to make statutory changes, in our view, they are going to push the outer edges of the existing statute through this agenda to see what they can accomplish. So, Bert, let's get into that agenda.
Let's go to the next slide, and we'll give you a feeling for what's on her plate. The most important element, in her view, is the way in which union organizing has been undermined and union elections have been tainted. So most of her far-reaching memoranda, this one is, as it turns out to be 2106, talked about how to penalize employers during the organization and election process. And these are, to an old labor lawyer, these are at the outer edge of what you can think of as a penalty. Bargaining order is the ultimate solution. It deprives the employees of their vote, and the board, if the court approves, imposes the union on the workforce regardless of the outcome, and they issue a bargaining order. In addition, you know, the normal relief is back pay, reinstatement. That's about it. At the far edges, you might get an injunction. But look at the nature of the kinds of penalties that Mr. Abruzzo is proposing. Bargaining orders, as I said, reimbursement of collective bargaining expenses. Not sure how you compute those. But look at these. The rest are as if it were a tort, a slip and fall, an accident. Consequential damages, beyond back pay, front pay, which is the pay you might have had, liquidated back pay, which is doubling your back pay, like under the ADEA, healthcare costs. Just think of all of the additional consequential remedies. Whether it is possible under the NLRA to impose these expanded remedies is something that's going to be tested. But that's a separate issue. Just look at what the General Counsel is proposing as part of what would be her norm for an election.
So
we can move on. David, there's more.
What the PRO Act would have imposed was civil money penalties. We don't have the PRO Act. A lot of these consequential damages in that little green takeaway box, that isn't something we created. That is General Counsel Abruzzo's, one of her tweets. This is her summary of what these key consequential damages are, which are very widespread. Nita.
I was going to say the other thing to think about is, in light of the ETS decision by the Supreme Court and all of the pushback on the administrative state, what she is really doing, I think, is going to be subject to a lot of litigation and not be particularly favorable, I think, to the board when it's all said and done.
That's probably true. That's probably true. Every one of these is going to be tested in the courts.
Well, let's look at some of the other, because as I say, but wait, there's more. So the agenda continues with this concept of, again, since the statute does not include civil money penalties, that could have been added had the PRO Act been enacted, but it wasn't. So nonetheless, General Counsel Abruzzo says, well, I'll just take the existing tool I have and reimagine ways that really sanction employers. So the concept here, and they're spelled out for you, some of these are increasingly far-reaching and candidly unprecedented. Bert mentioned before about the reimbursement for organizing costs, training to employees under the Act, requiring an employer to provide contact information by granting equal access to the employee bulletin board. Contact information means you provide all employees personal emails, personal cell phones to the union, all that sort of information that typically, when an employee provides that to an employer, is done for a limited, usually for emergency or other immediate basis. Nita.
One of the cases that the Trump board just overturned was requiring employers to provide their, their web-based, their emails to the unions. This goes way beyond that, in my opinion. So clearly, they're going to flip that again, Bert.
Well, one of the issues and one of the problems facing Mr. Abruzzo and the board is that in order for some of these penalties to be imposed, you're going to have to change existing board precedent. The case you talked of, Purple Communications, would be opening up the employer's email system. That's not legit anymore. So a lot of these things will have to first get a case, next get a board ruling, then get a judicial approval. But as I say, that's for later. For now, we know the direction of where this board is going. And if we go to the next slide, we may see the most far-reaching of all, and in some cases, the most troubling. If we could see Abruzzo's Agenda 4, you'll get a sense of what I'm talking about.
Oh, there we go.
3, now 4.
So,
I love
Bert, go ahead and
technology, except when it doesn't
start to
work.
unpack 4 while we're doing that.
Well, frankly, at the end of the road, all of these cases come to the point where, like with the OFCCP or the EEOC, there's a negotiation between the government and the employer for how to settle the case. And out of the blue, Ms. Abruzzo overtly stated that any settlement that she will approve has to be 100% of what could be won in litigation. And plus an admission by the employer of wrongdoing. And you obviously, well, first off, that's so far beyond anything that's ever been sought. And common sense will also tell you that there are not many employers that are going to accede to a settlement that's as bad as losing in litigation. From my point of view, all that means is we're going to have a lot more hearings, a lot more cases, a lot more litigation. This is the iron fist without the velvet glove. This is what she says. If you get in trouble with the NLRB, it's 100% or nothing. From my point of view, that means we're going to have delay. Every case is going to be litigated. We're going to have delays at the board. We're going to have delays at the court. And just as an observer, delays usually work to disfavor the unions because the workforce changes, events change. So the fact that we're building in delays in the name of serving the workers and the unions, it just may not happen that way.
Bert, the only slight amendment I would make, the quote settlement, which normally implies some level of compromise, not only has no compromise, it would require employers to pay a premium, to pay more than they might expect under a current law, and to also include an admission of violation, which could impact their eligibility for receiving future contracts, could impact their ability to secure loans, etc. So, but here it is. So you'd have to pay 100 cents on the dollar, and it's not clear whether some of these other components also would have to be paid. So, anyhow, it's aggressive, and I agree with you. It does not incentivize early resolution in any way, shape, or form. This goes back to it's a overtly pro-union agenda. Come heck or high water, it appears. That appears to be General Counsel Abruzzo's effort. All right. Well, shall we move from the General Counsel's agenda to the next slide and talk a little bit about the actions the board is taking? So this starts with, and this really now begins, we want to drill down a little bit. We've talked about that the board, Bert gave us that teeter-totter slide and talked about how the board wants and is willing to change its prior precedents. There is no rule of stare decisis. And so I think most clients want to know, okay, so what's on the chopping block? What's going to be changed? Well, thanks to General Counsel Abruzzo, we know the answer to that with great certainty. and there are 3 hallmark rulings, and the first we want to really start with is employee conduct, the so-called Boeing case. We'll talk about that a little bit. Micro units and independent contractors. All 3 of those, I would point out that the employee conduct and the independent contractors, those are of interest to all employers, whether you have unions or not. The micro unit is specific to who can be organized, how you get organized. That's a little more technical in the traditional union. But for those of you that are in the, I'll call it roundly, the 95% club, you don't have union employees and you're wondering why you're listening to a webinar on the NLRB. This is why, because employee conduct now may become cognizable under Boeing and also the independent contractor. So Bert, let's go to that employee conduct and talk about what the Boeing ruling was and what it looks like is going to happen.
Yeah, I'm pretty sure that if anybody listening knows anything about board law, this is probably where it begins and ends. In 2017, there was a change in the law. Under the Obama administration, many people, including many board members, thought that they'd gone too far. The whole point of this, and as David and Nita have both said, this covers everybody. The nature of the law is to protect concerted protected activity, which is supposed to be commentary and activity designed for terms and conditions of employment, not individual gripes. It's a kind of group help. And under the Obama board, we got to the point where individual Facebook postings were regarded as concerted protected activity. There were other advances of not making investigations confidential and things of that ilk. So pretty clearly that seesaw had tilted. And then in 2017, it tilted back under the Boeing case, which gave employers a much stronger right to control employee conduct. That has stuck in the craw of many union supporters. And in an interesting way of going about it, the board, rather than simply ruling on a case before it, this case called Stericycle, they asked for briefs from anybody. And I think in this case, the briefs will be due in just another 10 days. They wanted to get a kind of notice and comment from the regulated community on what the new handbook rules should be. And one of the interesting things, groups like the EEOC and many others have said you've got to keep investigations confidential regardless of how you change. You've got to preserve the right that people can't have two jobs working against one another. They want to keep some notions of non-disparagement. So how the board analyzes this raft of briefs that's coming in and how they will decide the Stericycle case is one of the things that's going to be most anticipated. Nita?
One of the things I think, and you all should probably talk about this a little bit, is how important it is that non-union employers understand what Section 7 rights means. I think Google just got slapped in the face because they told employees they couldn't have communications around wages and benefits and other issues at the company. And that violates Section 7 because employees are allowed to discuss among themselves terms and conditions of employment. And so if you in any way discipline people for that, you violate the National Labor Relations Act. And I think, David, you probably have some other examples of situations where that comes up.
Right. And this is the area, this is, I would say, the most common tripwire that non-union employers run face-to-face with the National Labor Relations Act. This Section 7, terms and conditions of employment, the statute does protect the right to engage in concerted activity. Very simplistic example. An individual says, I don't think I'm paid fairly. Okay, that's about their individual terms and conditions. On the other hand, if the individual says, I don't think any of us are paid fairly, we're all being mistreated, that is protected conduct under Section 7. You're complaining about the pay system. So you can appreciate how the level of communications that are very common, particularly during the pandemic, on how employers are conducting themselves easily, and many of them fall into these areas of Section 7.
Yeah, and one of the interesting elements, and that's why this decision is going to be so important, is that with the rise of social media, the burden of trying to decide what is a personal gripe versus I'm being mistreated, my bosses are unfair. Is that a personal gripe, or is that about the terms and conditions of employment? What is the meaning of concerted protected activity? And as we've pointed out before, every employer should be aware of how this impacts their workforce. Every employer may have to re-examine their employee handbook as the results of Stericycle come to be known.
Right, but it does put a premium on general, I'll call it traditionally accepted instructions. This investigation is highly confidential. Please don't discuss it. Your pay. We pay each person based on merit, but it's important that you respect the pay process. Please don't discuss your pay with your peers. Very common instruction that's been historically given. Potentially violative. Okay, we'll work out some arrangement because you have a family situation. We will give you a little leniency, but come on, don't tell everyone that because, we still have an operation to run here, but we're going to take care of you because we like you. Those are things that many would view as, responsible supervisors may have made those types of statements and been viewed favorably. Each of those statements potentially could be cognizable as being violative of Section 7 rights. So I think that, this illustrates an important takeaway, not only monitoring this development, and we've, I think, foreshadowed what we expect. There is going to be a change, and it's going to be even more encompassing, but it will necessitate that employers now recalibrate what their instructions are, policies, practices. Supervisors need to be retrained.
Yeah, and the only thing I would add to all of this, and it's to restate the point that Nita made as we opened, all of these decisions are subject to judicial review, and there is a new wind blowing through the courts, which are very skeptical about administrative regulations. So stay tuned.
But the problem is, of course, that takes several years to get there.
Yeah, it will take years.
All right.
Yeah.
Well, let me talk about the second of the three big areas that we referenced, micro units. And this is, I don't know if it's old wine in new bottles, but it's a topic that's been around quite a bit. This is the one that directly relates to union organizing and how which employees you can organize and how they're organized. So to start with, the touchstone is that the employees have to share what's called a community of interest, And that might be more broadly cast. They all work for the same employer, or it might be more narrowly cast. They all work in one small unit, one small subset. So think if you were trying to organize in my hypothetical shipping warehouse, I'll call it Bamazon. Instead of Amazon, we'll just call it Bamazon, my hypothetical. And I had all the hourly employees that work in my Bamazon warehouse. And there's some on the loading dock. There's some that are pickers that get product and put them into boxes. And there's one that process orders in an office. Well, the question is, what is the community of interest? Who gets organized? Now, often this is a point of hot contention. The union may say, look, the loading dock people, we've had communications with them. We know they're very strongly predisposed to vote for us, to vote us in. There are 30 people back there. We think we've got 28 votes on the loading dock. We're not so sure about the rest of that organization out there in my Bamazon operation. So we'd like to have an election, and we'll organize the 30 loading dock employees. Well, naturally, the employer says, whoa, the community of interest, we all work for one company. We're all part of the production process. We need to put all 150 into this bargaining unit. So I've got the office people, I've got the people that are picking the orders, and the loading dock people. Obviously, that strategy results in a significant dilution, and that micro unit majority becomes then a likely unsuccessful minority of voters for the union. That's the dynamic that plays out. When unions have historically had difficulty winning larger units, the standard playbook is they go and look for micro units to pick off. It's like getting a beachhead. Once you get in, you get employees, and coworkers can say, oh, that's successful, or oh, seems to be working pretty well. Oh, you got a pay raise. I didn't. Then it's easier for the unionization to spread among the organization. So micro units is big. Obviously, what the board's doing now is openly considering in American Steel construction whether to return to a historically broader concept of what is the community of interest and allowing unions more leeway to create narrow constructs to allow the unions to create micro units to get those toeholds. Bert.
One of the ways I've always thought of this was a kind of political gerrymandering. This permits unions to pick their voters and pick their workers rather than the workers picking the union. And the most famous case, and the example you gave is less than what's really happened. The shoe department in one of Macy's department stores wanted to be their own collective bargaining unit, and the Obama board said, makes sense to me. And the difficulty, of course, is there were other unionized workers on the loading dock. You had one employer with multiple union contracts. it was a real mess. And this is one of the issues that will be hotly contested and, again, be tested in the courts. Nita?
I think the real reason, though, is when you look at some of the charts that we have on union organizing and the success in getting elections, the unions are not doing well. They may get people interested enough to have an election, but they can't seem to get them willing to actually vote. For example, the Amazon case, the actual Amazon case down in Alabama, I think.
Bessemer,
yes,
Alabama.
Alabama. Which, anyway, they lost that, and now they're going to get a do-over.
Well, as a matter of fact, fewer people voted for the union in the election than signed authorization cards to get an election. So it just shows you the dynamic. That's the dynamic that goes on during an election campaign. But
well, many people. It is historically true that many people are willing to sign an authorization card simply to get an election, but once they become more fully informed, that is, they hear the other side. It's just like a political campaign, Bert. It's a good analogy. Yeah. Sometimes voters change their initial views once they become more fully informed. Now, the union version is they change their views because employers engage in overreaching and unfair labor practice and threaten and interrogate and promise and survey and all those things that are prohibited. But those are issues that do get sorted out. But I think this concept of which employees can be organized and whether these smaller units where the unions, and it's much, I will say, as an employer advisor, it's harder to defeat micro-unit elections. I mean, we don't, we have a knee-jerk reaction typically of not wanting a micro-unit because once the unit, whatever the union picks, that's because they think they can win that, to Bert's gerrymandering point. So I almost always have a knee-jerk reaction to say, then we need to look at whether that's the appropriate unit and think about a different one. But
absolutely.
All right.
Well, let's move on to
most folks. Yeah.
This is the big enchilada. This covers again everybody, all employers, and let's start with the issue. Under our employment laws, people who are not considered employees do not have the protections of most employment laws. They don't have Title VII protections. They're not in Social Security. They don't have Fair Labor Standard protections. They don't have minimum wage protections. Everything starts with whether you are classified as an employee. And that is a serious problem that as our economy develops in the 21st century, somehow or the other, some very smart people are going to have to get together to figure out how to solve it. Right now, there are only two camps. Either you're an employee or an independent contractor. And again, this issue has bounced back and forth among the board, in Congress, in individual states. There is a movement now at the NLRB to invite briefs in a case to reverse the current standards, which are more limiting on how you characterize who's an employee. And modifying the test for independent employer would expand the number of employees, which means there are more people who might join a union, more people who get the protections of Title VII, get the protections of ADA, get the protections of ADEA, get the protections of Fair Labor Standards Act, get into Social Security. But again, this is going to be highly difficult. And the reason I say that is in California, they tried to do this legislatively in a kind of famous case called AB5, which really kicked out the jams and made it presumptively that people were employees. It turned out to be, perhaps because it was California, it turned out to be a screaming disaster because all the people in the creative arts said, wait a minute, you just deprived me of my living. I make a living working for 4 different people in a month. I'm no one's employee. I am a genuinely independent person. Of course, it was aimed at Uber and DoorDash and Lyft, and they organized a recall campaign, but that's another issue. The core issue that I want to address is how difficult it is to do this with a kind of hatchet rather than a scalpel. currently the board, again, adopting this principle of seeking briefs, a kind of notice and comment, seeking briefs in a case, oddly enough, at an opera house in Atlanta, because of all of the grips and all of the part-time workers they have in any entertainment environment. They've invited briefs to see, and frankly, I think it's a good idea to get a variety of ideas of how to address the issue of how do we establish who is an independent contractor, who is an employee, and even more important from my point of view, how do we extend the social safety net that was implied by the NLRA, by Title VII, and all the other worker protection laws? How do we extend those to the 95%, as it were, that aren't in unions, and the hundreds of thousands, millions, who regard themselves as independent? Nita?
One interesting point was the DOJ, Department of Justice, has filed one of those amicus briefs over worker status, as requested by the NLRB. It's interesting because the response, I think, of the courts may be that only Congress, going back to the ETS case, perhaps only Congress can change the definition of employee. Can the NLRB actually do it with the courts set up the way they are right now?
It's a fascinating question. They have left the NLRB portion of this to the NLRB, but David, you're going to tell us in a minute that other agencies are getting into the act.
Well, they are, and I just would point out that this issue of independent contractor, this is of acute interest to every single employer, whether you have unions or not, and because of the far reach of it. And the NLRB, Bert, as you mentioned, although the NLRB, I would characterize it as being on the tip of the spear, but there's a lot more thrust that this administration has. And let's jump onto that next slide and unpack that a little bit about this coordinated effort to really take on the independent contractor versus employee, and also the joint employer, which we traditionally think of as the tension between, in franchise situation, franchisor, franchisee. Is there a joint employment? But it arises in a lot of settings where we have many clients that use contract labor suppliers, and they have them embedded on their sites. Is there a joint employment between the employees of the labor supplier and the host company? Those are very common and often very difficult fact patterns. So to help kind of delve into that and underscoring how interrelated, although these are separate statutes and there are sometimes rather technical minor differences, but all the statutes only apply to employee. They don't apply to independent contractors, generally speaking. So the agencies, whether it's the Wage and Hour Division of the U.S. Department of Labor, whether it's the National Labor Relations Board, EEOC, other agencies, they all have an interest in getting this issue resolved consistently. And in this administration, expansively, that is to expand the definition of the workers that can be classified as employees, and to, if you will, challenge the classification of various contractors under this. The first step is they announced last month a new MOU between the DOL's Wage and Hour Division and the National Labor Relations Board. And interestingly, and this is so what we need to understand is, if your workplace is being investigated by the Labor Department, Wage and Hour Division, and there's an issue as to whether they will look if you have contract workers, and they will question whether they are properly classified. They also very well will, under this new protocol, provide employees with information on how to file an unfair labor practice charge. They've got a pre-printed form, an instruction sheet, because as I mentioned before, the Labor Board can't act on its own. It has to have a charge filed. So this goes out and it allows the Labor Department to do that. There also are going to be referrals. There's going to be exchange of information between and among the agencies. Note, employers, you are not apprised of these coordination efforts, other than the government has put us on notice that there's this general coordination going on. When you are being investigated by Agency A, say the Labor Department Wage Hour Division, under the current protocol, you are never told when and whether the National Labor Relations Board has been alerted, or when the EEOC has been alerted and brought in, or OFCCP, etc. All of these things go on below the surface, and the agencies are exchanging your information. Now, we have some strategies to try to address that. We try to say, look, this information is being submitted solely for these purposes to respond to your wage hour investigation, not for other purposes. But honestly, that's very hard to enforce, and this is a fairly new protocol. I would just put this joint effort that's underway. There's going to be a webinar tomorrow with the agencies I've just mentioned, Nlrb, Labor Department, and EEOC. Jocelyn Samuels is chairing it, moderating it. It's going to discuss exactly what we've just covered here, this heightened coordination, and I think that's one that's worth tuning into to hear how they plan to implement this further.
That one's focused primarily on retaliation, but yeah.
That's on the retaliation piece, but it also, which is another component. But Bert, do you have anything else either on the ICs, the independent contractor, or the joint employer?
Yeah. The thing that strikes me is that this is part of what appears to be an administration-wide effort to increase coordination among all of the labor enforcement agencies. There's not an MOU, but there's already been published documents saying that the EEOC and the OFCCP will work together more in a more coordinated way, that the EEOC and the Wage and Hour will work in a more coordinated way. So for really the first time in my memory, we're actually having an administration on the employment front that's trying to get the kind of coordination we've seen in other sectors, especially defense, especially technology. Now we're going to see it in employment enforcement.
I agree, Bert. And one thing I would say, when you have conversations with the leadership at these agencies, this is what they're talking about.
Oh, yeah.
They are talking about this coordination and implementation. So it is real. These aren't just sort of general talking points that are out there. Every indication is that the agencies are fully in on implementing these efforts. All right.
Indeed.
Well, so
final thoughts.
A few final thoughts?
I guess the one that I'm going to end where I began. You know, the Nlrb has been around since 1935, and all of a sudden it has become the best led, most focused, most aggressive agency in the government, and it's the one that will be working hardest to move the Biden pro-worker, pro-union agenda. They are very motivated, and they are very well led, and I think everybody, including especially employers without unions, has to keep their eye on this ball.
Yeah, Bert, and I really want to pick right up on that. I mean, for a relatively small agency, particularly due to General Counsel Abruzzo, they are going to really punch up way beyond their weight. And for that 95% out there without unions, you need to you need to raise your awareness of these developments. The question of misclassification, the Section 7 rights we've discussed, protected conduct. Those rules are going to be changing, and for obvious reasons, you do not want to end up on the receiving end of an unfair labor practice charge and be in front of this very aggressive agency, because it will be expensive and protracted to get out from under that. And this puts an even greater premium, since it could be even another government audit, like a wage hour audit or an OFCCP audit that could, or an EEOC audit, that could also have the consequence of getting you in front of the Nlrb. So I think better understanding, better awareness of these developments. Look, many of you had the luxury for decades of not really having to worry about this agency. It belongs on your dashboard along with the others. So with that, I think great discussion, and a lot more to come from the Nlrb.
Indeed.
Absolutely. Thank you, David, and thank you, Bert. Very good conversation, and we really appreciate that. We wanted to mention two things. One, on March the 9th, former Vice Chair of the EEOC, Leslie Silverman, and I will be doing a presentation on kind of getting you up to speed with what EEOC is doing. We are doing about every 2 weeks. We do our podcast. Please jump on, and we provide insight into what's going on in Washington. And in 15 minutes, you can find everything you need to know. And with that, Valerie, you want to close us out?
Thanks, Nita.
Yes.
Thanks for listening, folks.
We would like to thank you for joining us today. The next and final webinar in our 2022 five-part Workplace Agenda series will cover the EEOC on the cutting edge of emerging EEO trends. This webinar will be presented on Wednesday, March 9th at 12 noon. Be on the lookout for additional updates, which will be sent via email. Later today, you will receive a survey requesting feedback for today's presentation. You are able to submit suggestions for future topics through the survey. Thank you in advance for completing the survey, and of course, if you have any questions, you may submit them via email to info@fortneyscott.com.